today we'll talk about this specific issue. Since this summer, the data transfer mechanism known as Privacy Shield is no longer in use between the US and EU, and we'll talk a bit about what that means with regard to GDPR for businesses that want to do business, for US businesses that want to do business in Europe, and vice versa, and go into how Kubernetes and cloud native technology can be an enabler for solving for GDPR. This is the agenda. With a short intro, I'll talk a bit about what GDPR means, what the fall of Privacy Shield means in terms of implications. Then I'll turn over to Cristian. He'll go into a bit about the practical nitty-gritty details about how to actually solve for GDPR using cloud native tooling. And then at the end, we'll have time for Q&A. My name is Robert Winter, I'm the CEO of Elastisys. With me today, I have Cristian Klein and also Johan Tordson. Both Cristian and Johan have a research background in the cloud computing. Cristian is a Senior Cloud Native Architect at Elastisys and does a lot of both these kind of talks at international conferences, but also helps customers all over the world pretty much with compliance and security related aspects, and also develop our compliant Kubemetes distribution, which is a CNCF certified distribution targeted at compliant industries like fintech, regtech, medtech, and so on. Short intro: GDPR, Privacy Shield. I guess we have both a European and an American audience today. I guess this subject is mostly familiar to Europeans, but it affects US companies as well. So what is GDPR? It's a European law, so it's written in law in all the European countries. This means it's at the same level as, it's considered a human right in Europe. So it's the same level as getting food on the table and kind of those kind of topics. So it's very high on the agenda in Europe. It addresses transfer of personal data, which means that it has implications for how we do business in the kind of cloud-related industries outside the EU and outside the EEA area, which is there is the countries that are not blue in this picture. So what is personal data then? This is a relevant question. According to GDPR, personal data has a pretty broad definition, meaning that pretty much anything that touches on a kind of a person or can be used to identify a human being is considered personal data. Some examples are names, of course, personal identification numbers, anything about location, biometrics, or online identifiers such as your IP address. But it also has a pretty wide range of other identifiable factors that indirectly can help identify a specific human being. And this is very important because this means that if you're not a machine-to-machine business, if you somehow deal with humans, which most organization does, you very, very likely handle personal data. So to know if GDPR applies to you, first check if you serve EU customers. If you're an international business, you probably do. And second, have a look at what your application actually does. Most likely, you process personal data in some manner. If humans are in the loop somehow, you're probably touching personal data. If you have some kind of sign up to your service, if you're a SaaS company, for example, if you have any kind of customer register, you're handling personal data. If you handle any kind of indirectly identifiable information, like track people's location or store chat logs in Elasticsearch, or pretty much anything that can be used to backtrack and identify people, then you're also consider handling personal data. And a lot of stuff like email addresses, for example, if you store a single email address and that email address has the format of robert.winter@elastisys.com, that is also personal identifiable information because that can be used to identify me. So it's a pretty broad scope. And GDPR has a few terms and requirements that I quickly want to touch upon, just to give a feeling for what this actually means for businesses. GDPR has 3 terms. GDPR talks about data controller. This is the entity that owns the processing of the data. This can be a hospital, this can be an organization which brings in the actual users and are responsible for the management of the personal data. Data controllers in turn use data processors to manage and process this data in any way or form. I think the simplest example would be kind of a cloud provider where you run your applications and store your data. That is a typical data processor. And a data subject is any individual in the system. Some examples of the requirements then that GDPR poses on you. GDPR is very strict on that you shouldn't keep data longer than necessary. It's also very strict that you should do everything in your power to prevent kind of the loss or unauthorized access to any kind of personal data. Users should have the right to be forgotten, which is much simpler said than done. GDPR also wants you to build data protection in your application by design and by default. So by default, your systems should be secure for data. You're also obliged to keep records of all kind of processing activities, i.e. logs are very important in GDPR. And you're also obliged to notify both supervisory authorities and the data subjects whenever a personal data breach has occurred. You need to do this very quickly. So GDPR puts a lot of strain and a lot of requirements on how you actually both build your applications and how you kind of manage your processes around it. How is this enforced then? How can people make you live up to GDPR? There are something called data protection authorities or DPAs in each country that follows GDPR or similar rules. These guys and girls are responsible for keeping track and fining companies that doesn't follow GDPR. And the fines can be either 4% of the turnover or the euro turnover for a company, or 20 million euros, whichever is greater. We had a recent fine just a couple of days ago. H&M was fined in Germany for the slight sum of $41 million. But that pales a bit to kind of the top 3 fines. I think most of you guys probably heard of this. British Airways was fined by the UK regulator. Marriott, this is a US company, was fined by also I think the UK regulator. And Google was fined pretty recently as well. The topic of privacy is also considered an international trend, and many countries have adopted similar laws inspired or one-to-one with the GDPR. For you guys in the US, CCPA is a thing that is in effect from this year, which is very similar to GDPR. It's implemented on state level, so in California, not on the federal level. But I think the trend is very clear, and other countries like Japan or Canada have similar kind of laws in place since a couple of years. Good to know when we get into talking about the privacy shield is that EU has a list of countries that they consider to have adequate GDPR level of protection, and which are kind of okay countries for any EU organization to send data to without any kind of privacy shield like data transfer agreement. And those are basically the countries in this list: Andorra, Argentina, some of the kind of closer countries to Europe, but also some further away countries like Uruguay, for example, also have kind of similar data privacy rules as Europe. So getting into privacy shield then, what has happened exactly? Privacy shield before the summer, that was a data transfer framework implemented to allow EU companies to make data transfers to US companies with the same level of protection as the previous countries listed on the last slide. This is really good, and it allowed kind of simple flow of data between the EU and the US. This summer, the EU Court of Justice invalidated Privacy Shield, and that is the picture on the right, where this guy, Max Schrems, who has been driving this case and similar since before 2015, is very happy that kind of this Privacy Shield agreement was finally brought down. What the EU Court of Justice found was basically two things: that the FISA law that the US has and the Executive Order 12333 doesn't provide enough protection for EU citizens' personal data. So this is kind of the overarching problem, that the US has quite strict surveillance laws, while EU has quite strict privacy rules, and they don't really match up in a good way. And Max Schrems, who is an Austrian privacy activist, was onto this already back in 2015 when he filed the original Schrems 1 complaint. There was something similar in place back then, a data transfer mechanism called Safe Harbor. Max didn't like that, so he brought it to court, and they had to tear it down. Soon after that, they put in place Privacy Shield, which was pretty much Safe Harbor all over again, but with a few twists and turns. Max quickly turned around and also challenged Facebook's use of something called standard contractual clauses, which is basically a contract between companies, where Facebook in this instance promises to handle personal data in a manner that is equivalent to how it will be handled in the EU, pretty much. This is a Schrems 2 case, and this ended up this summer with the EU Court of Justice bringing down Privacy Shield and invalidated that as a transfer mechanism. So, in the basics of this, I mean, it's two different cultures. In the US, the government believes that it needs access to personal information to protect its citizens. EU countries believe that it's a human right, basically, to decide over your own personal data. So it's these two views are in very clear opposition. And judging by the kind of current US political debates at the moment, this will probably kind of not change anytime soon. So for companies doing business, both in the US and in the EU, this is something we probably need to take into consideration for a long time going forward. Why is this important then? So basically, under GDPR, which affects pretty much all of us, as a data controller, you're responsible for your data processors, no matter where they are. So any kind of service you run, ranging from IaaS to PaaS to SaaS, you are responsible for the compliance level of that service. So no matter if you're running virtual machines on top of AWS, or if you're buying an Office 365 subscription, or using any other service, you as a data controller are responsible for how personal data is managed if you send it away. And the big thing here is, of course, is that the US pretty much has a monopoly on modern hyperscaler cloud services. Over 2/3 of public cloud workloads run in US data centers. And the big thing here is that it's the legal jurisdiction that matters, and not so much where the data centers are actually located. Of course, the big hyperscalers have data centers all over the world, but the actual location where your data is stored doesn't matter. It's where the administrators that have access to your data, where they live. So if you're handling EU citizens' data, you're using illegal services. This summer, over 5,000 services have been relying on Privacy Shield as a mechanism to transfer data. There's a long list of companies that have signed up and adhere to Privacy Shield. If you're using those services, and relying on Privacy Shield, that's currently illegal according to EU Court of Justice. What are the implications of this then? Basically that most companies in the world are currently in somehow or some way using legal services according to GDPR. There's been a few surveys or kind of there's been a few surveys kind of looking into how people are actually responding to this. And overall, I think the picture to the right is pretty telling. There's a lot of uncertainty, so a lot of people have no idea how they will go forward. And there's also a lot of status quo. There's a ton of work involved, actually moving workloads and switching providers. So until further notice, a lot of organizations, especially those that doesn't really worry a lot of about compliance on a day-to-day basis, they are just sitting tight and kind of holding on. NoYB, which is Max Schramm's organization, did a pretty complete survey with a lot of the big US service providers like Facebook and AWS and Salesforce and all the big ones. And the takeaway was that pretty much none of them could say how they actually will go about handling the fall of Privacy Shield and the EU ruling. And so kind of from all sides, both from the end user side and from the vendor side, there's a ton of uncertainty, and it's still very early days. These are extremely long processes, and it's still up in the air and under a lot of discussion what this actually means and how the courts will go about handling this situation. I think the big takeaway here is that if you are an organization with a kind of mature approach to compliance, where compliance is important to you, you need to do kind of your risk analysis and think about what data do you process and in what way should you handle it. I think that is the big takeaway. The question is basically, will you somehow be held accountable for not following GDPR? And depending on what the industry you're in, I would say that this is very unlikely at the moment. If you want to comply with GDPR, though, kind of what are your options? How can you go about it? We'll talk about one option later on, which we consider to be Kubernetes and Cloud Native software, but there are also other ways. The first option that you usually hear a lot about are standard contractual clauses or binding corporate rules. These are basically company-to-company agreements where you can kind of set up an agreement with any of the big cloud providers or any of the service providers you use in the US, and they promise you that they will manage your personal data on an adequate level. And the thing is, the EU Court of Justice didn't shoot down SCCs as a mechanism during the ruling this summer, so they are still valid. You can still have contracts, of course, with any company you want. The thing is, the pretty long text to the right, it puts the EU Court of Justice put a ton of responsibility on you as a data owner to actually make sure that if you rely on standard contractual clauses, that you put the correct supplementary measures in place. And what these supplementary measures would be, that is still a bit up in the air, and it's not very clearly defined. The thing is, to use this, you would have to ensure that US laws, like FISA or the Cloud Act, does not impinge on the level of protection that are required from GDPR. So it goes a bit without saying that if you have a contract with a company and the government comes knocking on the door, I don't think that the contract is worth a lot. But one way of going about it, one very popular supplementary measure, is to encrypt personal data that you handle. And this is, of course, very good. You can either encrypt data in transit, you can encrypt it at rest, or you can try to encrypt it in use, which is pretty hard. The thing with this is that you would have to, a lot of the cloud providers say that they kind of allow you to encrypt your data, so it's fine with GDPR. But the thing here is that it's your responsibility to make sure that data is actually encrypted all the time. So kind of all the way from being transferred over the internet to kind of being stored in memory or at disk to being processed when users actually run your application. And this is not extremely easy or potentially even doable in most cases. Another way, which Facebook and others have started doing, is to try to get explicit consent from your data subjects, i.e. the users of your services. This is a bit tricky because according to GDPR, you can get consent from data subjects to transfer data, and that can make it okay, but it requires very specific writing, and it has to be kind of, the consent has to be very specific. So this is still not tried in court, how you can actually go about and get consent from users in a good way. Another way, of course, is to minimize the amount of personal data that you actually store. So you can remove as much personal data as you potentially can. You can anonymize personal data, or you can pseudo-anonymize personal data. The difference being with when you can pseudo-anonymize data, you can always get the original data back. So you can always get the personal data back using kind of mapping table or keys. While when you anonymize it, it's anonymized. You can never get the original data back. And all these, just to be clear, if you would actually get audited or kind of have someone come and look at your GDPR compliance, of course, doing all this stuff is of course good. So kind of it reflects very well on you, but it doesn't necessarily make you fully GDPR compliant doing any of this. And the fifth thing, which kind of we consider might be the kind of the easiest technical solution, is to use EU providers for running your EU related workloads and storing your EU personal data. And this is where cloud agnostic solutions like Kubernetes and other cloud native tooling comes into play. We'll talk a bit about this, then I'll hand over to Christian. Basically, if you're looking into EU cloud providers and you're looking to run some kind of multi-cloud setup using the big American hyperscalers and combining that with EU providers, there are quite a few, but compared to the big American providers, the EU providers are spread all over the place. And besides OVH, which is a big player, most of the European cloud providers are kind of semi-small and have a historically, EU providers have mostly been providing IaaS services, but recently there's been a lot of interest in the question of data privacy and the whole data sovereignty of Europe. So a lot of the big European companies like Germany and France feel that it's time, this is a great time for Europe to step up and also provide their own kind of IT infrastructure services, which you can argue is hugely important in today's modern society. So there's been a renewed focus on this topic, and a lot of these European cloud providers are really kind of pushing ahead and trying to at least get up to par with the American hyperscalers. We work with most of these providing our services, so we know them quite well. But in general, you can say, I mean, AWS has a ton of services, and the service catalog of a European cloud provider kind of can't compete in terms of number of services. But if you're looking to run workloads in the EU, at least you get kind of the most important services are available at most cloud providers. That was the overview. Now I'll turn over to Christian to talk about how you can actually go about using Kubernetes and cloud native tooling to build this foundation and to comply with GDPR, basically.
Yes, so thank you, Robert. Hello, everyone. Like Robert introduced me, so I'm Senior Cloud Architect at Elastisys, and I'm kind of at the intersection between InfoSec and compliance and how to make the best use of cloud technologies and cloud native technologies to solve these issues. So let me start by saying that whenever we're talking about GDPR or compliance, this is really happening at several levels. you are kind of responsible for making sure that compliance is happening in all of the layers of the hardware and the software stack. So if you're looking at the lowest possible level, the hardware, topics that, or controls better said, that are dealing with such issues are things like physical security. Do you actually know who gets into your data center and who can touch your computers and who can steal potential hard drives, personally identifiable information out of your data center? And of course, infrastructure as a service security. So making sure that somebody cannot just SSH into the host and then steal data out of the VMs that are running there. Now, fortunately, Europe is pretty mature on this particular topic. So all of the vendors that Robert has previously shown, they are very serious about security at this particular level. And most of them have also some ISO 27000 certification. And when I say ISO 27001 certification, I kind of need to remember a horror story from a friend that basically said that, yeah, he had some platform in an emerging market and they claimed to be ISO 27000 compliant. But then when he actually went down, he noticed that they had a server hole that was kept, let's say, less secure than I would typically keep my computers in my own cellar. Anyway, what I want to say that this is really not a level that you need to worry about if you're going to Europe. Then, of course, you have the platform level. And here you have various controls that you need to deal with, such as monitoring, intrusion detection, logging, keeping your operating system patched, and so on. And then on the highest level, you have the application and company level. And it is pretty easy to think that, well, this is where most of your efforts should be going, right? Because it's the application, for example, that in the end takes all the personal identifiable information. And of course, it's your staff that should be informed not to download all your personal information and leave on a USB stick from the premises. However, in this presentation, we'll be talking mostly about the platform level. And I just want to say that compliance and GDPR bring some, let's say, subtle implications at this platform that we really want to make you aware of. So let me start by, on the next slide, let us reiterate the cloud native definition. So let me read it aloud. Cloud native technologies empower organizations to build and run scalable applications in modern dynamic environments, such as public, private, and hybrid cloud. These technologies enable loosely coupled systems that are resilient, manageable, and observable. Combined with robust automation, they allow engineers to make high-impact changes frequently and predictably with minimum toil. So I have highlighted the words that, at least to me, are the most important in this particular context: public, private, and hybrid clouds. So although we tend to think about Kubernetes as being this managed service that is running on top of one of the hyperscaler, cloud native technologies are actually very much intended and usable on any kind of cloud, including the European ones. So then if we're looking on the next slide on the cloud native foundation landscape, the CNCF, so the one that came actually with this particular definition, is organizing projects in plenty of categories such as database, streaming and messages, and remote procedure call, and so on. So it kind of feels like there is an answer to any kind of service that you would need in order to satisfy your application requirements, even if you do not have these as managed services. So let me just give you some example of such services. On the next slide, we have highlight. So what I really want to say here is that this cloud native technologies should really allow you some cloud agnostic compliance. So this means that basically you can use cloud native and Kubernetes as some building blocks so that you can run your application workloads seamlessly under both European jurisdiction, so as to keep personal data more protected, but also, of course, American jurisdictions, because that's probably where your customers are. And by embracing cloud native technologies and Kubernetes, you're avoiding vendor lock-in. And like I previously said, this really enables you to handle European personal identifiable information under EU jurisdiction. Let us get a bit more concrete on how you achieve this cloud native agnostics. So we have taken here some AWS services, and let me just say that AWS is a really great cloud provider out there. I have worked with it in many projects, and it's absolutely great. So praise to that team. However, in this particular context, there is a big problem with AWS, which is that it's a US-based company, and that depending on how exactly the privacy shield discussion will unfold, you might get into trouble with using their services. Now, for the positive part, however, most of the AWS services have some kind of cloud-native alternative. So if, for example, you're using a message queue such as simple queuing service, then there is NATS as a cloud-native computing project that allows you to do that. If you need something like object storage or block storage, so the equivalent of S3 or EBS, you have Rook, which is a pretty mature project and that allows you to deal with that. Container registry, Harbor. If you need a highly available relational database, so which is automatically replicated across multiple availability zones, Vitess offers a solution to that. TiKV, key value stores, and I'm not sure it makes sense to go through all of these services one by one, but let's just say that the options seem to be there. It's just perhaps a little bit more configuration hassle, but there are ways of making your application run smoothly without too much overhead and still embracing cloud agnostic compliance. Okay, so just because you're using cloud native projects doesn't necessarily mean that you're automatically GDPR compliant. So let me spend a little bit more time. I cannot really give you all the details, but let's just go a little bit through some of the more technical GDPR articles and show you what exactly are the implications on how you're using cloud native technologies. So we have here selected, let's say, the GDPR articles that we felt most important with respect to their technical implementation at the platform level. And like I said, we cannot go through all of them, but let us just focus on the ones that are being shown here in bold. So if we take the first one, you need to, these articles basically point down to the classical questions of controls. If you're familiar with ISO 27K or another compliance framework, you really need to make sure that you're using these projects in a way that you develop also these kind of capabilities. So capabilities such as access control, such as technical vulnerability management, such as network segmentation to make sure that an attacker gaining access to part of your infrastructure, to one microservice, cannot move laterally and infect and also take data from another microservice. Intrusion detection, audit logging. You need to make sure that you have some backup and disaster recovery. And GDPR has a subtle implication not only on actually doing backup and disaster recovery, but also how you're doing backup and disaster recovery. And also, I'm not going to list all of these controls, but for example, right to be forgotten is also a very important capability that you need to develop also at the platform level, and that has implication of how you're configuring your cloud native projects. Okay, so let's talk about Article 5.1f. By the way, if you're having trouble falling asleep and you feel like you're needing a little bit of help, I totally can recommend you to print out GDPR and just leave it by your bedside. If that doesn't help, then I really don't know what the cure could be. But anyway, if we were to disassemble a bit the legalese and look at these articles from what they mean in their pure technical interpretation, Article 5.1f really means that you should try as much as possible to prevent accidental loss of data and unauthorized access of it. And now, I'm not sure how you are configuring your Kubernetes clusters. I would be very keen to know more about this. But what we have seen at most of our customers is that pretty much they just take the cluster admin token and then share that among their development team or maybe their operation team, and everything is good and fine. And of course, this puts you in a little bit of a risk when it comes to GDPR, because in case the security of the cluster is compromised, say, for example, by a rogue developer or maybe just by an honest mistake, then it's very difficult to identify who exactly was responsible for that change. Also, generally using the cluster admin token or private certificate is a long-lived credential, which again puts you at a risk. So therefore, one of the first things that we would suggest you is to really protect upgrade the authentication to your Kubernetes clusters and use something like DEX in order to allow it to tap into your identity provider of your corporation. And this is done usually via OpenID Connect or via the protocol called SAML. And of course, there you would do the OAuth dance, so to speak. And that allows you to have way more and way stronger authentication. You can, for example, deploy two-factor authentication that creates a token so that you can get access to the Kubernetes cluster, but that's generally valid for only 12 hours. So that significantly reduces your exposure to unauthorized access. And then just for making this presentation that appeals to my geeky sentiments. So if you're, for example, using kubeadmin in order to set up your Kubernetes cluster, that pretty much means that you have to worry about this line, the prefixes that start with OIDC, and you just need to make sure that you have a proper OpenID Connect issuer. So that's generally, like I said, the DEX that you would host in a different Kubernetes cluster or in a different part of your infrastructure. And then, of course, you need to make sure that you're providing your Kubernetes cluster with the right where to find the username claim that is then afterwards interpreted by the role-based access control infrastructure, which is built in Kubernetes, and also where exactly to find the group claims that, again, has implication on how you can do role-based access control. When it comes to accidental loss, Velero seems to be the leader when it comes to backing up your Kubernetes cluster, in particular persistent volume claims, and also the Kubernetes resources. But as I will show on the next slide, there are some implications on how you need to configure these things to make sure that they don't interfere with GDPR. So then let us head over to Article 17. This is known in its short form as right to erasure or right to be forgotten. So what this basically means is that whenever a data subject, or simply said, a user, is coming knocking at your door, perhaps sending you an email, they have the right to basically just claim, yeah, I retract my consent, I want you to forget about me, and I want you to delete absolutely all of the data that can personally identify me and that refers to me. So that is, of course, something that I would imagine is mostly an application side decision, right? The deep database schema and what data is stored where, that's generally application side concern. However, it also has a little bit of implications on how you do, how you configure your underlying platform. So for example, we just discussed Velero, and for disaster recovery purposes, there is kind of a pressure to make backups as often as possible and to keep them for as long as possible. But this, according to GDPR, is no longer okay, because you might get into trouble if, for example, somebody asks for their personal identifiable information to be erased, and then you're performing disaster recovery, or for example, you're restoring for backup for some kind of reason, for example, a code change that didn't go quite well. And then suddenly the data that was requested to be erased is getting restored. And that's a complete no-no. I mean, for that thingy, I can imagine that you will be very quickly escalated to high levels of the courts. So then next time when you're configuring Velero, don't just let the default TTL be configured, which is currently 30 days, but try to have an honest discussions with your risk department of what should be a good value for time to live here. And in case of doubt, probably something like 7 days or maybe even 24 hours might make sense. Similar implications are also happening for logging, for example. So our experience shows that it's very convenient to have rather broad logging. So for example, to log database queries or to log API response and request, and especially also between the microservices at their border. And this, of course, makes perfect sense, and it's a legitimate reason to do so, because you want to be able to make sure that your system is up and running and to inspect issues that can only be detected in production. However, this again can put you into a bit of trouble when it comes to personally identifiable information, because you cannot just store this information forever, since personal data might make into logging information. So again, there you need to be mindful and configure, for example, Elastisys Curator to delete logs after a certain time, just to make sure that personally identifiable information don't make it past their expiration date. Let us pass on to the next article. So Article 25 says pretty much data protection by design and by default. Now, what exactly the legislator has meant by this is still up for interpretation, but if one were to take the broadest possible or the strictest possible interpretation for it, that kind of suggests that you should have a proper information security program running within your organization. You should probably have something like a chief risk officer, and you should train your employees to rotate their passwords and so on. That at least to me kind of sounds like the spirit of this particular article, although I don't think anybody that is currently bound by GDPR actually applies to that extent. However, if you are currently, let's say, already applying a little bit of InfoSec and let's say want another reason to give to your chief risk officer to invest more in information security, then Article 25 can definitely give them this extra energy in organization to do so. And I have also already discussed how authentication can help you to make sure that, well, you're securing your cluster against unauthorized access. We also suggest you to use some very strict pod security policies, and I have shown here a snippet that we typically like to recommend on the right. So with, for example, disable privileged containers, because otherwise any kind of pod is pretty much capable of taking over the host and move laterally. We also like to drop as many capabilities as possible. And this is a very important remark because, for example, there was recently a CVE, a common vulnerability and exploit, that has sent all the Kubernetes admins running to upgrading their Kubernetes cluster. And if, for example, you had dropped all the capabilities of your pods, then pretty much you could have just enjoyed your weekend or your beer or whenever that CVE was released, knowing that since a certain capability is required to be able to successfully exploit that CVE. So if you drop all those capabilities, you have nothing to worry about. Another thing that you might want to make sure is to allow only a whitelist set of volumes in your pods. So for example, some like host path is a complete no-no because again, that allows you to escape, for the pod to escape into the host VM. And of course, you want to set plenty other pod security policies that furthermore restrict what your pod can do. Now, I put pod security policies in a bit of a question mark. My understanding from the last KubeCon is that this is a bit of an uncertain API that hasn't really managed to move past beta. And currently people are recommending to perhaps even complete deprecate pod security policies and just use something like Open Policy Agent or some kind of generic policy agent project in order to enforce these kind of policies when as part of a Kubernetes admission controller, so a bit like a Kubernetes API firewall that would not allow you to run any kind of pod as privileged. So we discussed also logging, and then Cert Manager, of course, can help you to make sure that you're encrypted, to encrypt all your traffic via TLS over public networks. I think that nowadays, thanks to efforts such as Let's Encrypt, there is really no excuse for anybody to use plain HTTP over the public internet. Last but not least, you should also think hard about encryption at rest. So this is to, for example, mitigate the attack of somebody stealing hard drives and then leaving with personally identifiable information. However, I would say that do your homework, but mostly this is something that's already dealt with by European infrastructure as service providers. Okay, having cleared this, these articles, I think I can skip this article. It's just, yeah. So as you have noticed, I hope I managed to convince you that just using cloud native technologies is, of course, a very solid roadmap in order to obtain cloud agnostic compliance. However, you have to configure this in very careful ways in order to be GDPR compliant. So then I have shown you some of the nitty-gritty details. And of course, it would be extremely difficult for all of us to remember all of these details, and it would be a tons of effort for each and every single Kubernetes administrator to go over GDPR and to see exactly how each article applies to their cloud native stack. So in order to reduce this compliance burden, we at Elastisys have released Compliant Kubernetes, which is a CNCF certified open source Kubernetes distribution. And its aim is pretty much to allow you to reduce your compliance burden when it comes to GDPR, but also other compliances. And the way we have architected is that in the middle, you're having your cluster with your workloads. And in these, we run a minimum number of tool sets, for example, for log forwarding and intrusion detection. However, all the rest, let's say the the most important topics for compliance are running actually in a second Kubernetes cluster where we collect logs and metrics and where all the alerts and all the detected intrusions are being stored. So this is in order to conform with what is often suggested by security experts to make sure that your logging environment is tamper-proof, where tamper-proof can generally be interpreted as if an attacker managed to gain access to your production workloads, they should not be able to remove or change any logging entrance. And we have, of course, bundled plenty of projects to give answers to GDPR. So Prometheus and Grafana, of course, for gathering metrics and logs and creating alerts, Elasticsearch, Fluentd, and Kibana for logs. And then, Open Policy Agent for firewalling the Kubernetes API, Falco for intrusion detection, Harbor for technical vulnerability management, so to make sure that the images you put in production are lacking or without any vulnerabilities, or at least to make sure that you're becoming aware of potential vulnerabilities in production before it's too late. Now, on the next slide, so Compliant Kubernetes is, of course, you're free to download it. It's open source. And basically what it offers is a security hardened Kubernetes cluster with guardrails and best practices for compliance. However, I also do understand that compliance of the platform might be a little bit of a topic that is off-putting to your company, because really where your focus should be going is on the application and how exactly to not only to develop features, but also to make your application comply with GDPR. So in order to allow you to focus on your primary mission, Elastisys also offers compliant Kubernetes as a managed service. And we, of course, offer enterprise-grade SLAs. And we are very happy to sign data processing agreements. So for those who are unfamiliar with what this means, it's basically a contract mandated by GDPR between our customers and a Kubernetes provider. That basically means that we're going to make sure that the platform is being managed and the personal information is going to be protected as mandated by GDPR. And we, of course, take care of everything from upgrading your clusters and making sure that all of the components I've just shown you are properly upgraded, so as to make sure that, well, you can focus on compliance on the application level, and otherwise the data privacy is ensured during the whole application lifecycle. Yeah, we have also started to build the compliant cloud native stack. So often our customers are coming to us and saying like, well, Kubernetes for stateless workloads is really nice, but I somehow need to store also my data. So inside compliant Kubernetes, we're also running, for example, MariaDB as a stateful system, which is automatically backed up and highly available, so that again, and of course run in a compliant manner, so that again you can focus on your application and we deal with all of the other compliance issues. Yeah, so let me finish this talk now so that we also have some time for questions and discussions. The main idea that we want to present here is that GDPR really implies a strict handling of personal information. Among others, you're liable for breach reporting, for data minimization, and also for data protection. GDPR has had a very interesting development lately, Schrems 2, which basically creates a barrier to transferring personal information from the EU to the US. Fortunately, this could be also seen as a blessing for cloud native and cloud native technologies and the Cloud Native Computing Foundation, because these technologies are pretty much offering building blocks for cloud agnostic compliance and for dealing with GDPR. And of course, we have packed together best practices and subtle implications that GDPR has on how to manage these kind of projects. So therefore, we are launching the Compliant Kubernetes open source project, and you're very welcome to check out the project at its .io website. With that being said, thank you for your attention.